Hello everyone, welcome to LiveLaw. Today we have with us Advocate Namit Saxena, Advocate on Record, Supreme Court of India. Namit was ranked 2 in the AOR exam held in 2019. As there are just 20 days for the exam this year, we would like to know some tips and tricks to score more marks in the AOR exam.
Thank you for having me, Anna. Uh, Although you're right in saying that 20 days only are there, we'll sort of, just see what all, we can do. We can help students or aspirants who are writing the exam this year, and what can be the possible tips to score more and more marks this year. So, as we all know, there are 4 papers, and I think from 10th of June they are starting this year, and for the third paper, one will get 2 days gap as well. So primarily, let's discuss today what all can be the tips to score more and more marks, because one has to get 240 marks out of 400. Instead, unlike being a competitive examination, these are subjective papers, so you have to score more and more marks, minimum 60%. So the more you score, the better your chances are to clear the examination. So one of the primary tricks which I tell everybody is that before you start, the first thing to start the preparation for the examination is that you go through the previous year question papers, because there are a lot of questions which are sort of repeated every year, and there is a pattern which is followed in most of the papers. And there are few questions. For example, for the paper in practice and procedure, we generally see the powers of the registrar and the powers of the chamber judge. They are sort of asked alternatively for different marks almost every year. And in certain years, they have asked both of them as well. Now, this is something which one has to sort of mug up, because although in practice we use few of the provisions and few of the powers of the registrar and for the chamber judge, but a lot of these provisions, a lot of these powers we actually don't use frequently. So these set of around 14, 15, 20 powers which the registrar or the chamber judge has, they have to be prepared from the perspective of if, in case it is asked for a 15 marks question, or in case it is asked for a 5 marks question. So it has to be prepared from both perspectives. In case it is a high high number of marks are will be awarded if in case you answer it properly, etc. So it has to be prepared from that perspective. So the first things first, one has to look at previous year question papers so as to understand what is the pattern, what is asked, etc. What are the repeated questions. Another very commonly asked question is on doctrine of merger, and whether what is an SLP, and a few judgments on those. So I'll just briefly say what is an SLP. So an SLP is a special leave petition, a special leave to appeal, because there is no appeal provided. But because if a question at all is asked on this, one has to start from saying that appeal is always a creation of a statute. Appeal, without a provision for appeal, there can't be any appeal. So Article 136 primarily is a special leave to appeal, with an exception of armed forces, etc. Any judicial order, administrative order can be challenged under Article 136. So the prayer and the format of the pleading of SLP strictly has to be as per the Supreme Court rules, but it has to be followed in the manner that it is not strictly a plaint, it is not strictly a pleading, but it is sort of a petition. Why I say why the difference is there? Because in plaint you have to sort of show what is the cause of action. There are certain restrictions in a plaint, and unlike Article 131, which we have the original jurisdiction, because in plaint you can't plead evidence, you can't plead law. And in pleadings also generally, as because wherever Supreme Court rules are silent, the provisions of CPC they sort of apply. So one can't sort of strictly put an SLP into the bracket of pleading also. It is a petition where you can plead questions of law, you can plead law, you can plead evidence subject to whatever was there in the low courts below, etc. You can plead everything. So SLP, and that is why the prayer in an SLP is also that you please grant me leave to appeal. So there is no right to appeal as such, but you are seeking court's leave to please grant me leave so that I can, I can have my petition filed. Another very crucial difference which a lot of candidates which I've seen, they sort of do it is that, for example, if it's an SLP criminal, so till leave is granted to appeal, it remains SLP criminal. Only after that leave to appeal is granted, where that expression, the magic words of leave granted come, then it gets converted into a criminal appeal, where the Supreme Court rules say that after leave is granted, there are certain formalities which are to be taken consideration of. So SLP primarily, strictly, as I said, not a plaint, not a pleading, but a petition generally. That is why the prayer leave to appeal also. Now another common question is on doctrine of merger, and when can we again go into review before the High Court after filing of an SLP, etc. So the locus classicus now on the entire issue of merger, and this is coded distilleries. That is 2019 4 SCC 376, and prior to it we had Vinod Kapoor, Konya Ahmed, etc. There was another judgment, another set of another line of judgments by Gangadhar Rao, etc. That is all overruled now. So coded distilleries is the locus classicus, which lays down as to what will happen. What is doctrine of merger? When does a lower court's order gets merged with the appellate court's order, etc. So that is something which every aspirant should read, and that is why Justice Sikri, three-judge bench, and what are the reasons given as to what actually happens when you seek leave to appeal. So this is one of the locus classicus in particular, and this will help in practice procedure as well as for the question paper in drafting as well.
Okay. Coming to drafting of an SLP, the integral part of an SLP is affidavit and verification. So can you tell us more about that?
Yes, that is very important. See, what generally happens is, in an affidavit, although there is a strict format which one has to follow, and in a lot of times, a lot of question papers, they've actually asked that you draft an affidavit simpliciter. Now, the verification clause in that affidavit is extremely important. Now, verification is primarily of two things, affirmation of two things. One, the facts which are in personal knowledge of the deponent, and facts which he believes to be true or are based on the legal advice. So, particularly not only in SLP but also in plaints under Article 131, that affidavit, that verification clause is extremely important. For example, if the plaint is divided into, say, for example, 37 paras, SLP would always be in para 128 as per the format. But say, for example, the plaint runs into 37 paras. Now, out of these 37 paras, the deponent believes the facts which are there, the facts and the facts in issue or the cause of action, they're in paragraph 1 to 23 or paragraph 1 to 23 and paragraph 25 to 30, say, for example. So the verification clause will, carry an expression that para 1 to 25, 1 to 23 and 25 to 30, I believe to be true and they are based on my personal knowledge. Rest submissions, para 20, 24 and para 31 to 37 are based on legal advice, which I believe to be true and correct. No part of this is false, and accordingly, I swear this affidavit for filing of this plaint or this SLP. So this verification clause is extremely important, which I think must be, and people lose out marks on this because they simply write I verify para 1 to 37. So this is very important.
How do you draft a prayer section in a petition?
So it will depend upon the kind of petition. For example, in an SLP, as per the format given by the Supreme Court rules, one has to seek leave to appeal. That please grant me leave to appeal against impugned order passed by so-and-so High Court, dated so-and-so, passed in so-and-so. So the date, the High Court's name, the date of that order, and the petition number before the High Court. And then, of course, pass any other order as you may deem fit. But when you file a writ petition, in a writ petition, like for example, Article 32 is worded like this: writ, order, direction, or writ, or any direction in the nature of these 5 writs. So the expression which is to be used in an Article 32 petition is to be strictly followed by whatever is written in Article 32. So this is something which I always say. See, any draft, a draft is a very technical document. It is not supposed to be an expression of whatever you want to say to the court. It is not supposed to be a novel as such. You don't write things or facts at a novel length. It's a very technical document. So whatever expressions you're using, those should be legally tenable expressions and legally followed expressions. So the expressions put in Article 32 have to be followed as it is. Similarly, when you draft up, when you're seeking a bail, for example, in a criminal appeal, you're seeking a bail. So in that bail, you have to say that please grant me bail in connection with FIR number so and so, or the sessions trial ST number so and so, to the satisfaction of the trial court, and you have to give the details of the trial court. So when the order is passed, that order will be because generally in bail orders they say subject to the satisfaction of the trial court. Now you have to give details of the trial court. So in the prayer section, you have to say, in case you are asked for drafting of a bail petition, you have to say to the satisfaction of so and so, the trial court, because the trial court will impose conditions upon you. In a lot of cases, Supreme Court does not impose any conditions as such on bail. The trial court will do it. So you have to mandatorily mention. So if in the question paper you asked to do it, you mention it. This will, and this is important. People lose marks on this.
Can you tell our AOR aspirants more about judicial review?
See, another very important question, and this is also very commonly asked. judicial review primarily, and this is from the perspective of drafting paper as well as practice and procedure, because 32 and 226 also can be asked, 32 primarily can be asked in practice procedure also. So judicial review primarily is of legislative action and of administrative action. Now, in case if, you have to draft a writ against a legislative action or by the parliament or by some state legislative assembly, it will primarily be on 2-3 grounds. One, if there is a violation of a fundamental right. Second, if there is violation of any part of the constitution, any other provision of the constitution. Third, for lack of legislative competence to pass that particular legislative enactment. So this is these three primary, although there are other grounds, shocking conscience, etc., are there now, but these are the three primary grounds on which a legislative action can go. Now we have manifest arbitrariness also, and that is a very important background in case a standalone question is asked on manifest arbitrariness. So one must start with McDowell's case, that is 1996, where Justice Rohinton Nariman, then he was senior advocate Rohinton Nariman, he actually asked that even that a legislative enactment can also be declared unconstitutional for being manifestly arbitrary. This was argued and expressly rejected by a 3-judge bench, saying it can't be. It is only for administrative actions, which we'll come on to. Now, when Justice Nariman became a judge, eventually in Shaira Bano and Joseph Shine and Navteej Singh Johar, all these judgments, they sort of used and they expressly overruled McDowell's case. And they said that legislative actions can also be declared unconstitutional because of being manifestly arbitrary. Now, these are primary 4 grounds for judicial review of legislative action. Now, for judicial review of administrative action, we have procedural impropriety, if there is excessive delegation, if there is irrationality, if there is a doctrine of legitimate expectation, or if there is an unfettered discretion not used properly, etc. So administrative and of course legislative incompetence, etc. So legislative actions and administrative actions, subject to what is asked for you for the aspirant to draft on an Article 32 petition, it has to, the grounds are separate. And in case the question, for example, is that if something is inserted in the 9th schedule of the Constitution, now the parameters of challenge to a 9th schedule law is different. That is in IR Coelho, which is also a part of the leading cases judgment. Now, para 148 of the SCC version of IR Coelho's judgment, and I think in SCR it is para 150 or so. It says if there is a 9th schedule law, because and in case, and this is also interesting, this is also important to note, in case a 9th schedule law, in case any question is asked on 9th schedule. So in 1950 we adopted the Constitution, and in 1952 the first Lok Sabha elections were held. But the Constitution was amended by the very same Constituent Assembly which brought in the Constitution in 1951 by bringing in the 9th schedule. So, and the reason why 9th schedule was brought in was because the then ruling establishment brought in certain land reform laws which were overturned by the high courts, etc. Different high courts, different land reforms in different states. So the ruling establishment then thought that we will keep passing laws and the judiciary will keep sort of overruling them. So we should have something where if we put a law in a particular section of the Constitution, then it should not be amenable to judicial review. So initially Constitution had 8 schedules. So they inserted the 9th schedule in the Constitution. And in this 9th schedule, they said that whatever is there in the 9th schedule will not be amenable to judicial review. So this went on. Finally, in IR Coelho, the law was settled. And this is after 24/4/1973 when Keshavananda Bharati's judgment came. That is a very important date for the purpose of this examination also, because Keshavananda Bharati is also there in leading cases. So IR Coelho now says if there is a challenge to a 9th schedule law, then it has to be first tested at the pedestal of whether it violates any fundamental right. In case it violates any fundamental right, then it has to be checked whether it violates a basic structure doctrine. And only if it satisfies that both these fundamental, part 3, that is fundamental rights, as well as basic structure doctrine, if both of them are getting violated by that law, only then it can be declared as constitutionally invalid. So this expression that it is not subject to judicial review is gone. It is subject to judicial review, but the judicial review, the parameters of judicial review for 9th schedule laws are comparatively much higher. So the idea is whenever you prepare a question, for example, this question which you asked, it has to be prepared from the perspective of practice procedure drafting as well as leading cases. So this will help in last few days of your revisional work as well.
So, there are a lot of landmark cases that an AOR aspirant has to go through. So, how do you particularly go through so many leading cases, in a
Yes.
span of 20 days before the exam?
So the trick to score more marks is that you do two things. Of course, you'll have to go through the SCR head notes and you have to see what is the majority opinion, what is the minority opinion, who were the judges who passed that judgment. But it is important to score more marks. It is important to see the background of the judgment as well as the follow-up of the judgment. For example, let us take Selvi versus State of Karnataka, which is in that list of leading cases. Now, Selvi versus State of Karnataka has a very interesting background and a very interesting follow-up as well. So from this perspective, a judgment is to be approached. Not only simply sit, reading the head notes and they ask, that is going to give you very average marks. Because from the examiner's point of view, it has to have something extra to give you something extra. So from Selvi versus State of Karnataka is a 2008 judgment of the Supreme Court. So from 2001 to 2008, we saw a lot of terrorist attacks across the globe. In India, for example, in 2001, we had 9/11 in the US. Then in India, we had 26/7, etc. So a lot of terrorist activities happened from 2001 to 8. Now there used to be this Dr. Narco. Dr. Narco invented this truth serum, and she used to inject, and this was primarily in Bangalore, in a lab in Bangalore. So she used to inject truth serum to the accused who were, sort of accused in these terrorist cases in UAP, etc. And they used to extract confessions from them, and those confessions were treated as against the accused as such. So this was eventually challenged, saying that this violates Article 20, Clause 3, because this goes against the principles of self-incrimination and testimonial compulsion. Now, this is the background of this. Another background of this is this 1964 judgment called Kathikalu Ogar. That is a 8th judgment, very important judgment for the purposes of testimonial compulsion, etc. So Selvi said that nothing doing this practice of lie detector, BEAP, and brain mapping, etc. This is, unless this is voluntarily done, or this exercise, the entire exercise is done under some sort of voluntariness by the accused, this is all sort of invalid. You can't involuntarily extract confessions like this. Now, so you write whatever happened in Selvi, etc. This is the background. Then it has a very interesting follow-up. For example, we have this Identification of Prisoners Act 1920, which was last year also, that was scrapped, and the new law came in 2023. So there for example, for taking voice samples, etc., there has to be some application made. In case the accused is not voluntarily giving it, you have to make an application under Section 73 Evidence Act to the concerned magistrate, and the magistrate can allow you to do it. Now, there was a challenge made in this judgment called Ritesh Sinha, which was ultimately referred to a 3-judge bench, and a 3-judge bench answered it. So Ritesh Sinha primarily said that no, you can't do it, because for invoking Section 4 and 5 of the Identification of Prisoners Act, you have to first arrest him. So you can't, unless the accused is arrested in that particular matter, you can't do it, etc. There are certain restrictions. So it got referred to a 3-judge bench. So by that time, due to a flux of time, Section 311A was inserted in CRPC. So why all this is important is, in case a 20-mark question is asked on Selvi, and from all these questions you have to prepare from the perspective of, in case a 20-mark question is asked, what all do you have to write? And in case it is for 5 marks, then you will have to cut short. That's one of the major tricks. But you have to prepare it from the perspective of writing a 20 marks long answer. So then Ritesh Sinha said that it can be taken voluntarily. So all these, Section 73 Evidence Act, 311 is CRPC, 45 Evidence Act, then Ritesh Sinha, Selvi, Identification of Prisoners Act, all these acts are very, very important from the perspective of writing an answer on Selvi. So this is one of the questions how you have to prepare. Another step, for example, if there is something asked on reservation. Now you have that in the table of 64 cases, there are few judgments which are from the topic of reservation. So they have to be prepared as if they are in connection with each other. I don't know if Bangalore Water Supply is there anymore, but Bangalore Water Supply also requires that 2 more judgments. After that, 7 judges and 9 judges got referred to in Jaibir Singh, etc. So the follow-up, the background and the follow-up of all these judgments is important. That is the tip to score more marks.
Okay, so one of the most common questions that is asked is about contempt of court.
Yes.
So how does one approach?
So it is important from the perspective of practice procedure and drafting, because a contempt can be asked to be drawn. and leading cases, although there are few cases from the contempt jurisdiction. So of course Article 129 is there, but one has to understand, one has to start from what is contempt actually. So contempt primarily is, and also see the power of the Supreme Court, the power of the Supreme Court actually lies in the restraint in issuing contempt. So contempt is the right of the people of this country to have an independent and fearless judiciary. That is why contempt is extremely important. Now, Article 129, of course, but there are rules by the Supreme Court to govern the contempt proceedings of the Supreme Court. And Supreme Court, of course, can issue contempt of lower courts and other high courts as well. So these rules were framed in 1975, the Supreme Court rule 1971, and something as basic as this: in case, unless presence of the contemptor is actually dispensed with by an order of the court, that contemptor has to be present in the court. Also, another very small thing which people miss out is that contempt goes by the name. So, if, for example, if there is a pending proceeding, and if it's a civil contempt, and the Supreme Court has asked, and for civil contempt there has to be willful disobedience, and the Supreme Court has asked some officer to do certain things, and that officer does not do. So, for example, if the cause title initially was XYZ versus state, so the contempt cause title would be XYZ versus PQR. PQR is that individual who has against whom contempt is lodged, alleged contemptor. In criminal contempt for the Supreme Court, one has to take opinion. One has to take a written consent from the Attorney General or Solicitor General. It can't be invoked directly. Because why? Because criminal contempt is scandalizing the court or lowering the authority of the court, or something which tends to scandalize or tends to lower the authority of the court. So these expressions are very wide for criminal contempt. For civil contempt, there has to be willful disobedience. So contempt, and then there are certain cases which, and there are a lot of cases. So one has to, again prepare it from the 20 marks answer, and one has to keep these basic principles in mind, because in these basic principles is what people actually miss on marks. So contempt is important from all three, and in fact in professional ethics also. So contempt is one area which is relevant for all 4 question papers.
How do you divide time for all 4 papers?
So for the paper on practice and procedure, I would recommend that you answer the questions which carry more marks first. For example, if there are 3 questions or the 2 questions which carry 20 marks each, and then 10, 10, 10, then 5, 5, 5. So answer questions which carry more marks, first, because, for example, if you're not unable to manage time, and at the end of the paper you're left with 120 mark question, so you lose on more marks than in case it is only a 5 mark question. So for practice procedure, this for drafting, I think because I think 30 minutes are given to read the question paper first. So while those 30 minutes are extremely crucial, you can make pointers and you can highlight in case you are writing by hand. Now we have the computer system also this year, so you can highlight whatever are the relevant facts, and you can highlight whatever are the issues or what is actually asked. A lot of people, a common mistake which a lot of people do is that they'll in the drafting paper they'll start writing everything. You have to just see what is exactly asked. In case they have asked you only to write the list of dates, then only write list of dates. Don't write synopsis or prepare SLP, etc. In case they have only asked you to write synopsis and list of dates, then only synopsis and list of dates, nothing else. In case only an IA, then only the IA and nothing else. With of course the complete set of IA. And of course one has to, in case one is writing by hand, then you have to start writing. You have to, so that you have a better pen flow, because you have to write from the scratch in the Supreme Court of India under Article 136 of the Constitution. Then you have to give the cause title, etc. Another tip is be very neat and clean from the the first page to the last page. It has to be very neat and clean. That will give you additional 5 marks minimum. So for drafting you can do this. For leading cases, again divide. For example, if they ask you 25 questions of 4 marks each out of 6 questions, so identify the answers which you are going to write, and answer the best question, the best answer first, so that you get more marks in the first answer. You develop a good impression on the examiner that this that the aspirant knows the drill, knows the deal. So you give your best shot first, and then eventually you can go forward. For professional ethics, time management is important because there are a lot of cases. So you have to divide. In case a question is asked for 20 marks, then you write 2 pages, 2.5 pages, 3 pages. In case the same question is asked for 5 marks, you'll end up writing half a page, maximum 1 page. So you have to divide the answer script in a manner so that you don't end up wasting time in less marks questions, and you write more in the questions which carry more marks. So this time management is extremely important if you're writing by hand or if you're typing also. Also, I would recommend that you keep last 15 minutes for revision. So you should manage in a manner that you are completing the question paper, the answer script, in 2 hours, 40 minutes, 45 minutes, so that you have some time for underlining or highlighting something or making a margin, etc., etc. So these 10-15 minutes for that quick revision at the last moment is extremely important. Also, another very important thing, because in those 4 days, you won't get time to write and revise, from the books again. So whatever notes you're making, just make those notes very handy so that the last moment you just go through those notes and nothing else, because you won't have time to read again, the entire thing again. So that this is one of the tricks which you can use. And of course, because there's you have to score 240 marks and 50 marks in individual papers. So the idea should be to score more and more. And how do you impress the examiner? By writing something which all others are not going to write. So if you succeed in answering 3 out of 4 questions in a manner that you're giving something extra from what others are offering, then you have already cleared the exam. So this is one of the major tricks that I can share.
Thank you for these tips and tricks, Namit. I'm sure it will immensely help all those giving the exam this year.
Thank you so much for having me, and all the best to all the aspirants.
Thank you for watching. Make sure to like, share, and subscribe.